Welcome everyone to the first webinar for the BFSLA Academic Committee, and also the first webinar this year for the Ross Parsons Centre at Sydney Law School. My name's Jason Harris. I'm a Professor of Corporate Law here at Sydney Law School, and I also chair the BFSLA Academic Committee. One of the things that the BFSLA Academic Committee does is provide seminars for BFSLA members on topical issues, and particularly issues where the interest in the membership also coincides with the research activities that the membership committee are currently undertaking. I've written about the PPSA in the past through my co-authored book with Nicholas Mirzai, the annotated PPSA. I've also written some articles. And our main presenter tonight, James de Cizel, who's an associate at Norton Rose Fulbright, where he's worked for the last 5 years. A graduate with first class honours from UTS, where he did his thesis on the PPSA. James has also written extensively on the PPS in a number of different journals, so you might have seen some of his work, particularly around extensions of time in the PPSA. And so I've asked James along tonight to take us through some recent cases on extensions of time to register on the PPSR. So thank you, James. Before you get started, we also have a commentator tonight who unfortunately you can't see. We're having some technical difficulties with his camera, but his microphone's working, thankfully. And that's Associate Professor David Brown. David would be known to many of you on the webinar tonight. He's the co-author of the leading and most comprehensive work on the Personal Property Securities Act in text form, published by LexisNexis, which is now in its second edition. So no doubt you've read some of his work. David, of course, also had a leading role with the registrar's efforts to promote community engagement and understanding of the PPSR through his authorship of the Small Business Guide, which you might have seen on their website or seen some presentations based on that. David's a leading expert not only in Australia but internationally on the PPSA, and he's taught PPSA courses here in Australia, New Zealand, also in Canada and further afield. So thanks very much, David, for giving up your time tonight to act as a commentator.
Thanks, Jason.
So as I said at the start, this will be recorded. If you have any questions, feel free to post them up in your question box and we'll deal with those as we go through. But now I'll throw it open to James to tell us about some recent cases.
Great. Hello, everyone. Thank you, Jason, for that great introduction. To reiterate Jason's message, thank you very much for registering tonight and joining us for this webinar. I'd also like to personally thank Professor Jason Harris and Associate Professor David Brown for their time. So looking at the first slide here, overall I thought it would be best to approach this topic by giving a brief background to the Personal Property Securities Act and then going over the relevant provisions of the Corporations Act and the PPSA under which extensions of time can be sought. Following this, I will take you through 5 of the more recent judgments in the past year where these provisions have been considered and applied. Those judgments are listed on this slide. For each case, we will not just consider the relevant facts and approach taken by the respective courts, but provide commentary about how they fit into what is an ever-growing body of case law in respect to these applications. We will then end the webinar by opening up to questions from the audience, as mentioned by Jason. Thank you. So first of all, I'm conscious that not all attendees are necessarily banking and finance practitioners and may not be completely familiar with the PPSA. So in short, this came into effect just over 7 years ago and broadening with it a new regime of not only recognising, recording and enforcing security over personal property. This regime replaced what was the ASIC system of covering charges, as well as amalgamated almost all state non-land security registers. The PPSA, along with the amended Corporations Act and the Personal Property Securities Regulations, together gave rise to the Personal Property Securities Register, which is the main subject of our conversations tonight. The register is often referred to as a live public notice board, whereby secured parties who hold a security interest under the Act register that interest against the relevant grantor. A valid registration is a critical method of perfecting the security interests, which, all other things remain equal, enables a secured party to enforce its security over that personal property against third parties. It's worth noting that registration is not the only method of perfection, however, it is the most common and other methods are outside the scope of this webinar. There are a number of specific requirements when making a registration, depending on the type of collateral and the interest granted over it. The registration requirement shared amongst all of them, however, is timing. There are two specific periods of time which need to be complied with. Firstly, for all security interests other than purchase money securities interests, or PMSs, Section 588FL of the Corporations Act requires a secured party to register their security interest on the PPSA within 20 business days from when the security agreement came into force. Where the security interest is a non-inventory PMSI, the requirement is 15 business days. Now, it's important to note for people who don't regularly practice in the PPSR, the secured party can still register its security interest outside of these periods. However, doing so exposes it to a significant risk of losing the security interest, and particularly if that security interest is a PMSI, losing its superiority under Section 62 of the PPSA. So I'll now take you through the first provision, and that is Section 588FM of the Corporations Act. So 588FM operates in the context of Section 588FL, which should be considered first. 588FL provides that if a secured party has failed to register its interests within 20 business days from the security agreement coming into force, and the grantor is then subject to a critical event in the next 6 months, the security interest will vest in the grantor for the benefit of creditors generally. Now, a critical event can be the appointment, so it'd be the wind up of the company, the appointment of an administrator, or the entering into a deed of company arrangement or DOCA.
And James, can I just ask quickly, for those practitioners on the line who perhaps are still somewhat new to the PPS and have some fond memories of the old Chapter 2K, this 588FL, that's the PPSA equivalent of the previous 266 in the Corporations Act, isn't it?
Yes, that's correct. And in fact, the cases that approached 266 back then are still referred to in a number of the judgments, and actually it's in the first judgment that we'll be going through today as well. So when a security interest over personal property vests, so for example, when you fail to register within the relevant 20 business days, it's important to understand the importance of what vesting means. So when the security over personal property vests, it falls to the grantor for the benefit of creditors generally. The secured party who held the interest is not able to rely on that specific security interest for enforcement and priority purposes. Instead, it becomes an unsecured creditor in the usual course. Where, for example, this occurs in relation to a PPS lease, the lessor, despite being the legal title holder, loses its asset. This is not to be taken lightly, as demonstrated very early in the PPSA's operation in the manner of Made in Civil in 2013. Note, this vesting power has also recently survived constitutional challenge insofar as the acquisition of property on unjust terms in the 2008 decision of One Steel. So overall, the consequences of falling foul of the Section 588FL is often referred to as an insolvency risk.
Could I just make a comment, James, on the citation from Justice Gleeson at the top there? 588FL only applies where there is a registration as opposed to any other means of perfection. Obviously, registration is the main form of perfection in most cases. But actually, Justice Gleeson got that wrong in line 2, technically speaking, because it says security interest which was perfected or registered, but it's actually only registration that matters.
That's a great point. You're absolutely right. Oh, that's quite interesting. I wonder if that's been picked up in later judgments, something to look out for. So say, for example, if you fall foul of Section 588FL, you can seek an extension of time under 588FM. That is where the court has the power to order a later period of time than what was the 20 business days on Section 588FM. Now, the test there must be a failure to register. However, the failure to register does not just apply to a situation where no registration has been made. There may indeed have one been made previously, but also where that registration was initially contained an error, which made that registration invalid. In these situations, as we will cover, parties generally undertake new registrations and seek in order to extend the period of time for these registrations to avoid the insolvency risk as a preventative measure, notwithstanding that a critical event has not occurred. It's important to recognise at this outset that when you do undertake so for example, if you made a poor registration in January and then you've gone and realised there was an error in May and then make a new registration in May, when you're seeking an extension of time, that extension of time does not backdate it to your original registration. What it does is it focuses on when you made your correct registration, and subject to this order, it actually removes or decreases the insolvency risk period of 6 months. Now, the grounds under which sections 588 FM order can be made is extracted in the slides there, and we'll go through those in relation to each case. As I said before, an order on the 588 FM does not afford the secure party an early perfection date. It will remain the date in which a valid registration is made. For example, even if that was done a year after the security interest was entered into. One large footnote to note in this is that security interest must be perfected by registration, as helpfully noted before by David, prior to the critical event, albeit one day, for example. We'll demonstrate with the case of OneSteel in a later judgment earlier in the presentation that security interest must be perfected before the critical date. In the case of OneSteel, registration was made, security interest was granted, before the critical event, but then registered after. Justice Brereton in that case ordered that strict application of the legislation dictates that security interest vested and it cannot unvest.
So it's an extension of time provision. It's not an unvesting provision.
Absolutely.
Yeah.
Thank you. The second section we'll be looking at is section 293 of the Personal Property Securities Act. Now, this applies specifically in relation to purchase money securities interests. While a full examination of purchase money security interests is the scope of this webinar, they act as a security granted to secure the payment or performance obligation in connection with a specific asset, which would not have otherwise come into possession of the grantor without the secure party taking that interest. Personal property securities, so PIMSs are attached special priority, and the reason for that needs to be a little bit clear in that the PIMSy secures the monies against which that asset was purchased or brought into the asset pool of the grantor. The policy reason behind this is that secured creditors should not have the benefit of additional asset security in the event that it would not form part of the asset pool if it was not for the third party or being the PIMSy holder. Now, to be afforded the super priority status, the secured party must, among other things, register its interest within 15 business days from the point in which the asset comes into possession of the grantor or the security interest attaches to this personal property. Where party fails to do this, an extension of time can be sought similar to section 588 FM. Note this application does not relate to insolvency risk, and hence applications under both 588 FM and 293 are not mutually exclusive and almost always run together.
So I guess just to clarify again, for those who are on the line who perhaps don't deal with the PPSA on a regular basis, that you can have just regular perfected security interests that don't have this special priority that PIMSs can get, and you only get that if you comply with the timing requirements in section 62.
Yes, absolutely. I'll also state that PIMSs, or personal property security interests, only relate to specific classes of personal property and specific circumstances. So, for example, lease availment was deemed to be deemed PIMSy interests. So, for example, an all present after acquired property interests cannot be treated as a PIMSy.
Yeah, and it is important, of course, to check that the definition of PIMSy in section 14 meets what you're actually looking at. That raises a really good reminder for me, of course, and also for you, James and David, something I should have mentioned right at the start of the webinar. Of course, what we're saying here is just a general overview. I don't have a practicing certificate. I can't be giving people legal advice. You certainly do, James, but James is only giving us a discussion here of a general nature. And of course, if you want some advice on the PPS, you should have a chat to James and his colleagues at Norton Rose Fulbright. Sorry.
Thank you, Jackson. So in considering whether to grant an order for relief under section 293 of the Personal Property Securities Act, the court must take into account following circumstances and interests that I've listed there in sub 3 of section 293. We'll go through each of these in more detail in relation to the cases, but it's interesting to note the first criteria, that the need to extend the period arises as a result of accident, inadvertence, or some other sufficient cause, has actually been found by the cases to be the same factual test threshold as 588 FM. So a little tip is when you're going through these type of cases, if 588 FM is ticked in relation to accident or inadvertence, it will almost always be also ticked in relation to section 293. So an interesting point to differentiate 588 FM from 293 is that 293 does not ward off the insolvency risk, it actually affords the superiority to a security interest that over all other items, all other security interests over that item of property where it otherwise would not have. It's not uncommon for an order sought under 293 to consider the creditors that have registered in the interim whereby there hasn't been a registration made in relation to that specific property or property generally. There's a consideration that the court must give to whether those other creditors have conducted a valid search and relied on that search, not showing this registered PMZ interest. But we'll go through that a little bit further on in the cases. A practical point here is that while 588 FM and 293 have different potential impacts on other creditors of the grantor, in both instances, the courts have consistently ensured that actual and potential other creditors be joined in the relevant proceedings, given the opportunity to object. This is in line with the general policy objective of the PPSA to be transparent. So jumping into it, the first of the 5 cases we'll speak about tonight is that of Squadron Resources and High Lake Resources, which was handed down in August last year by His Honour Justice McCracker in the Federal Court sitting in Western Australia. Here, the plaintiff applied under Section 588 FM, seeking an extension of time for 2 years. By way of background, in 2015, the plaintiff had entered into a convertible loan note agreement with the parent company of the defendants. The defendants were grantors and the plaintiff was a security trustee under the note agreement. Monies payable under that agreement was secured by GSD over the assets of the parent company in 2015. Interestingly, in leading up to the execution of that GSD, solicitors for the parent company, or the grantor, offered to the plaintiff, the secure party, that they would register the security interest granted by their client, to which the plaintiff initially agreed. This is relatively uncommon, and often solicitors acting for the secure parties would want to take control of that action. Shortly thereafter, the plaintiff changed their view and confirmed with their solicitors that they would attend the registration, as of course they're acting on behalf of the secure party. The registration was then made under the parent GST on the same day in which it was signed in June 2015. Separately, a general security deed was also intended to be entered into with the defendants as subsidiaries around the same time, 2015. However, the subsidiary GSD required further amendments in order to carve out an interest that was already held by ANZ as a competing creditor. Based on His Honour's judgment, entry into the subsidiary GSD did not appear to be a condition precedent to the loan note agreement coming into effect or funds being able to be accessed under that agreement. The subsidiary GSD instead was actually not exchanged until late in June 2016. The plaintiff did not register security interest granted over it to the defendants at that time. It was not until June 2018 that the director of the plaintiff became aware of this convertible loan note transaction. It appears from the facts in the judgment that the director was not employing the plaintiff at the time of that transaction, but the search of the register in June revealed that there were no registrations over the defendants pursuant to the subsidiary GSD. It was important the court looked at the evidence of the particular director who took the view that no registrations were made, most likely, according to the judgment, due to a miscommunication between the plaintiff's former employees and their former solicitors. This was most likely based on the correspondence referred to earlier at the initial registration of the parent GSD. Now, in relation to the subsidiary GSD, all present after acquired property registration was then made promptly after the discovery of the failure to register earlier. Then the plaintiff then sought orders under Section 588 FM to extend the relevant period of time under 588 FL to account for this new registration. The reason being is that if the order under 588 FM was not granted, then the period in which the insolvency risk arose would then be from June 2018 for the next 6 months. If the order on 588 FM was granted and recognised the extended period between the initial registration in 2016 as extending to the date of the new registration, being 2 years later, the 6-month insolvency risk period would already been spent and decreased the risk in relation to the secure party. Now, taking this application, the court has to, of course, consider other registrations made against the defendants in that 2-year period of delay. It appears from the judgment only one had been made against the first and second defendants, which was to ANZ, which concerns a term deposit or an ADI account. In relation to the third defendant, it had already granted an all-PAP in favour of ANZ prior to the GSD, and subsequent to entering the GSD, it did grant security in relation to 6 separate PMZs, which would appear to be general operating equipment and machinery supplies. Now, initially, the application under 5A-FM for the relevant period extended 2 years, as I said before, would avoid the insolvency risk otherwise faced by the plaintiff. Now, the plaintiff advanced 2 factual bases from which they believe the failure to register occurred. That was that it was accidental or due to inadvertence, or there would be just and equitable to grant the relief. Thank you. In his honest reasoning, Justice McCracken not only considered the 5A-FM cases, but also, as Jason pointed out earlier, the prior Section 266 sub 4 criteria of the Corporations Act, which applied to company charges. His Honour stated they had continuing relevance and are often of assistance in guiding the court's discretion under 5A-FM. It's important to note that these provisions, so these cases were a very strong base in the initial body of law concerning 5A-FM applications, and it's good to note they're still considered today. His Honour then approached the test of inadvertence on a literal basis, and based off the evidence presented to the court, came to the view that the failure was inadvertent and was not of a neglected nature, i.e. the plaintiff did not consciously, or were not consciously aware of the requirement and just completely disregard the obligation. It appears was just inadvertent, and as a matter of course of business, it just didn't occur. Now, it's important to consider here the delay was 2 years. So His Honour cited the matter of Appleyard Capital, which was a 2014 judgment of, 2014 decision of Justice Brereton, who was a leading member of the bench in relation to this area of law. He stated in that case that the period of delay in effecting the registration, while relevant, was not the main determining factor. So the significance of the passage of time was mainly related to the possibility of competing interests having arisen, in particular through others having dealt with the company on the footing the collateral was unencumbered by undertaking a search of the public register. The next item that the court considered was the potential creditors to other creditors. As I said before, the plaintiff's evidence demonstrated that shortly after making the 2018 registration, the director actually wrote to other secured parties and informed of the application and gave them a reasonable period of time in which to be joined as a party and make an objection. Based on the judgment, none of the other secured creditors raised an objection. Now, as I mentioned earlier, there were other creditors that His Honour was considered to pay attention to. First was the later PPSA holders. And His Honour reasoned that, as I described earlier, PPSA registration is effectively a carve-out in relation to that particular asset over the overall asset pool. The plaintiff's application was in relation to an all-PAP registration, and so any PPSA registrations that occurred in that delay did not directly impact the security interests of the plaintiff. The second was also in relation to ANZ's account security, which His Honour correctly, of course, recognised that this was an ADI account security, and by way of Section 75 of the PPSA, also had priority over a general all-PAP. So in the net effect, if the order was granted Section 5A-FM, other creditors would not be prejudiced. In fact, they would have the same position they would otherwise have had.
So just to be clear, James, again, for the benefit of the non-PPS lawyers, so we've got a range of priority rules under the PPS. We've got your kind of standard perfected security interest, and that will be based largely on the time that you register. You've already told us about the super priority that PPSAs can get under Section 62 if you comply with the timing requirements. And then we've also got a range of special super priority, as it were, for banks with respect to control over ADI accounts.
Yes, absolutely. So after considering the potential prejudice of third-party security providers, His Honour granted the order. It's interesting to note, and it's very good to have as a background in relation to this type of cases, that it's not uncommon for the court to also, in their order of allowing the extension of the period of time, to give what's called a custodian securities condition to be part of the order. Now, this is a reservation in relation to the order that's made extending a period of time that allows a party to come forward and seek to overturn that decision if a critical event occurs in the following 6 months. This is quite a common order. It's often done to protect the interests of other creditors if a critical event does occur later on. Now, notably in this...
That's a Guardian Securities.
Guardian.
Oh, thank you, David. Now, notably, the Guardian Securities condition was not made in this instance, which is quite rare. In my view, this was likely due to the strengths of the facts and the clear indication that the other secured parties had a better positioning before or after the order was made. So the second case we're going through is the matter of Toll Energy Marine Logistics and Colin Murphy, which is handed down by Her Honour Justice Gleeson, the Federal Court sitting in New South Wales. Here, the plaintiff applied both under Section 588 FM and Section 293 for an extension of 215 business days. The plaintiff, Toll Energy, is part of the larger Toll group of logistics companies and provides, in particular, chartered vessels. In May 2018, the plaintiff had chartered the vessel to the first defendant pursuant to a written charter agreement. The vessel was delivered to the first defendant around the same time in May. Now, the terms of the charter agreement was that it was initially for 1 year, with 6 optional 12-month periods, by which the end of the customer was obliged to exercise the buy option. This fell within the amended PPS definition of the lease, which automatically granted it the ability to be a personal, say, purchase money security or PMSI.
And that's because one of the categories of PMSI in Section 14 of the PPSA is a PPS lease defined in Section 13.
Yes.
Yeah.
So here, once they were granted security interests, Toll Energy did not register within the 15 business days, nor did it register within 20 business days, which was required by 588FL. It actually registered much later, on the 25th of February this year, so 2019, so 215 business days later. The plaintiff put forward a couple of reasons in relation to the failure. The first was that while the Toll group of companies had considered the implications of PPSA at a general corporate level, when it came into force, it had not yet crystallised into a process or protocol amongst the group. Possibly, and as referred to in the judgment, could have been due to turnover of key staff who had received this training. The second was that the Toll group was not aware or conscious of the specific requirements of the PPS leases or engaging with PPSI generally. And this was only brought to the plaintiff's attention after engaging with external solicitors. So the basis was essentially that we weren't fully aware, while we were acknowledging of the PPSA, we weren't fully aware of the specific requirements and not yet actually formed an internal process.
It's interesting they should have talked to their New Zealand colleagues, because there's at least one toll case reported in New Zealand.
Maybe they should have, absolutely. But nevertheless, in this instance, when the error was discovered in February this year, the plaintiff made a registration on the same day. That was a PMSI registration. The judgment states that they also made another registration 3 weeks later in relation to the same security interest, but didn't actually go into what that registration was. As was the usual course, other creditors were joined in this application as second to fourth defendants. And it's important to note that these defendants all had all-paps over the first defendant's asset and had perfected their security interests prior to Toll's PMSI registration. So they had been granted these all-pap interests and registered in these 215 business days. So, as I mentioned before, the plaintiff has actually brought an application of 588 FM to avoid the insolvency risk, but also an application under Section 293 in order to obtain this PMSI super priority status. Thank you very much. So the first test was in relation to inadvertence. So firstly, the court considered Section 588 FM and then proceeded to Section 293. So in relation to 588 FM, as discussed earlier, the first point was in relation to inadvertence. In considering whether the circumstances of this case amounted to inadvertence, Her Honour refers to the judgments of Justice Brereton and Appleyard Capital and Justice Black in Cutting nominees. In both cases, the term inadvertence under the Act was read to mean more than just ignorance of statutory requirement to register, but that it may be established by an applicant where a party operates under a mistake as to the consequences of failing to register that security interest. Her Honour came to the view that the failure to register earlier was accidental based on the 2 reasons put forward. By determining there was actually an accidental mistake, Her Honour then did not need to engage with whether there was a prejudice to creditors or was just inequitable. However, she did note in OBITA that for later reasons under Section 293, she did not consider there was this prejudice. So Her Honour granted the Order 5A-FM, extending the business day requirement to account for the 215 business days, and thereby remove the insolvency risk, because Her Honour found that based on the facts, it was an inadvertent mistake that was made, and for reasons I'll cover shortly, it didn't impact the other creditors of the grantor. Thank you.
Next slide.
Yeah, thank you. So in relation to the next application, which was brought in Section 293, the reason why this application was brought was because this wasn't an all-PAP interest, it was a PIMSI interest, and therefore the secured party was looking to get this PIMSI super priority status. As discussed before, the first point that you have to consider when going through Section 293 is inadvertence, mistake, or error. And Her Honour acknowledged that test for inadvertence is the same under 5A-FM, and so this element, by reason of her earlier observations, had been satisfied. Now, as I covered before, with Section 5A-FM, that was simply enough to determine that there was prejudice to grant the order. However, the drafting of Section 293 is a little more onerous than that. Section 293 says the court must also have regard to potential prejudice to other creditors, and whether a person has acted in reliance of the period of time ending. This is because, of course, under Section 293, extending the period under Section 2, whole energy, in this case, super priority over the all PAPs registered in the interim. It's worth noting that Justice Brereton stated in Accolade Wines that while there may be an assessment of prejudice and prejudice may be found, it's not conclusive to guide the court to not grant such an order. Now, in relation to the other creditors, according to the facts, the second to third defendants stated they did not oppose the relief sought, and the fourth agreed actually to subordinate its interests behind tolls in respect of the vessel. So none of the second to fourth defendants sought to demonstrate any relevant prejudice in the case. So this is often quite helpful when seeking these orders to engage these other creditors, and these creditors in this instance did not oppose it. It is noted in the judgment, however, that counsel for the plaintiff acknowledged that if an all-PAP interest holder could demonstrate they had took their interest in reliance on the register, which did not contain the plaintiff's registration, then the court may be caused to refuse the relief sought. However, that was not the case in this instance.
James, can I just ask a question based on that? So would one potential tip for clients be that perhaps before they extend credit, they should be doing a search and keeping a record of that search, so that if at some point in the future there's one of these issues and maybe we do finally have a case where a creditor wants to oppose it, because so many of these cases no one's opposing it, that they can say, look, we did a search on the day and we made our credit decision based on that search, so our interest could be prejudiced.
Yes, absolutely. It would be a great evidentiary benefit to actually have that search there. Not only just search amongst the legislation registration requirements, also maybe conduct what's called a triple search, right, which to members of the audience that may not practice in this area, it's a search of not just the grantor's name and ACN, but also their ABN. For reasons that become apparent later on in the presentation, this search is widely used in the industry and will also be able to help identify any other potential registrations.
Just on that point about that Jason raised about, what you could do to kind of safeguard yourself against the future opposition of a creditor. There is a Mahajer case where I can't remember which judge it was, pointed out that third limb of 293 about reliance, for a creditor show they relied or did not, they acted or did not act upon the lack of registration. The judge in that case said that the creditor does not have to show a but-for test. In other words, they don't have to show that they made a decision about credit on the basis of what they found or did not find, more to the point, on a search. The judge said just have to show that they had a general practice of reviewing registrations and doing searches. So it's interesting sort of speculate about what would the onus be on a creditor who's saying that they have relied upon the state of affairs, how much they have to prove. And that obviously comes up in the IBM case as well.
Yes, absolutely. It'd be an interesting approach to be taken by the court. It'd be very interesting to see how that plays out. Because the evidentiary burden, of course, is on the plaintiff in these applications to show that creditors were not prejudiced. So while the other creditors will obviously have some evidentiary burden to show they didn't rely on, to show they relied on a search, it's also very interesting how the plaintiff would approach that to prove they did not rely. So maybe we'll have a case like that in the future. I personally hope so. But just in relation to tying off for this case, so with 588 FM order granted, Section 293 considered inadvertence established, and then considering that no other secured parties were objecting, Her Honour granted the order Section 293, which affords super priority status to this registered PIMSI. Her Honour did impose a guardian securities condition, however, for a period of 6 months. As I said before, so anyone, if a critical event occurs in the 6 months, they can bring this application. Side note, interesting point about this case was that when the application was actually filed, the first defendant was the subject of a winding up application. However, that was resolved by consent prior to the judgment being handed down. This may or may not have an impact on whether this guardian order was actually put in place.
Now, I've just got a question from the audience. So Alba asked specifically about this case. Does that mean that in circumstances such as the toll case, both Section 293 and 588 FM have to be met in order for the secured party to obtain the registration? Now, perhaps if I can add a comment there. Yeah. So Alba, it's a really good question. I'm sure there are others on the line who have a similar question. As James was saying before, we've got two different sorts of protection here. So the 293 protection is really about the timeframes to comply with the PIMSI super priority. Now that's under the PPSA. So if you can't meet the 15 business day or before possession, depending on whether it's inventory or not, requirement for Section 62 in the PPSA, then you can seek an extension under 293. The 588 FM extension relates to the Corporations Act, and that, as James was saying before, is really dealing with the insolvency risk. That if you don't register or have the court extend the time for registration within a certain period of time under the Corporations Act, then you can lose your security. So 293 has got nothing to say about vesting. That's about your super priority for a PIMSI against other perfected security interests, whereas 588 FM is really saving your bacon, because if you can't get an extension of time, then you're at risk of having a vesting if you have an insolvency event. Mm. Would you agree with that?
Absolutely agree.
Great. So hopefully that answers your question, Alba.
Yep. Great. Thank you. Let's go to the next case. And so I've tried to break up the size a little bit by adding a diagram, which I think may be actually helpful for this particular factual scenario. So this case is that of Flow Systems with the Minister as appointed, which was handed down by His Honour Justice Greenwood, the Federal Court Sydney in New South Wales. This was an application under Section 588 FM only. These proceedings concern a range of orders which were sought by the joint administrators of Flow Systems and its group of companies. For a background, this company operates a range of water, energy, and other utility development systems. The particular applicant here, Flow Systems, is the retailer of that group. Now, the financial arrangements of the group is quite helpful to understand how the court approached this. Their arrangements were largely documented back in 2013, which involved, among other things, a subscription deed, which was supported by a general security deed in favour of the security trustee. Brookfield was the major beneficiary under the security trustee. Now, administrators were appointed by the directors on the 20th of December in 2018. You can see the first point on the timeline there. The administrators then proceeded to negotiate a new interim funding arrangement with existing secured creditors. A facility agreement and a general security deed were then entered into on the 24th of December 2018 with the existing secured lenders. That was Brookfield. The administrators then sought multiple orders in relation to this, but in particular, sought an order on Section 588 FM to extend the period of time required to register the security interests. The obtainment of this order is actually made of condition precedent to the facility being effective. It's also worth pointing out here, just before we go a little bit further in the timeline, the distinction here between these facts and the facts in the case of One Steel. In the One Steel decision, the security interest was granted prior to, if we use this timeline, prior to what would be 20 December 2018, and then the critical event occurred, 20 December, and then it was registered after that period of time, and all it was sort of extending that period of time. Now, Justice Brereton quickly pointed out that Section 5FL still has an application in that circumstance, and that if it wasn't perfected by registration, as David pointed out before, and not by other means, it vests as at that day. Here, the facts were different, in that security interest was actually granted in the period of administration. So that's where you can point the difference, in that it was granted and registered in the period of administration. Now, whether this can actually occur in the period of registration is actually expressly recognised in Section 5AFL sub 2, which states that at the critical time, or after security interest arises after the critical time. So it expressly acknowledges the right to perfect the security interest by registration after the critical time has occurred. Now, this does not mean necessarily that security interest granted after the critical time and perfected by registration, for example, on the same day, does not vest. That they still do. Subsection B2 states that vesting will occur on the earlier of the time that is the end of 20 business days after security agreement that gives rise to the security comes into force, or the time is the critical time, whichever is the earlier. As you can see in the diagram, by the first red line period. So the earlier time here is not, so it's not simply that you've been granted the registration, say the security interest on the 24th of December, and then you have 20 business days. The earlier time is still technically 20 December. So it does not give you a leeway period. What it does is that if it gives you a window by which, if you've registered, you then can apply for an order extending that period of time. Without the order, security interest does automatically vest, because that's technically the earlier point in time, if it's not extended. Now, in relation to the other secured parties, it's only observed that administrators, before I jump into that, just to go through the diagram a little bit further, the order was then sought on the 31st of December 2018 for a period of time to extend to the 21st of January. What that would do is move the first red arrow mark section to the second section. The second section, red onwards, means automatic vesting. If the order is granted on the 21st of January to extend that period of time, it just means that the earlier point in time under 5AFL becomes the 21st of January. And so therefore, their registration is extended to comply with the registration timeline. So therefore, it wouldn't vest. So that's the example of where the new vesting period occurs after the order. So they've technically avoided vesting by safeguarding what the court would seem to be the extended period.
James, could I just ask a question which arose out of the previous seminar that Nick Merzai and Christopher Athanasius did on this subject? Nick was sort of making the point there that took this to its logical extreme. You could have a company which is returned to the directors, and then a year later or so enters into some security agreement and still technically falls foul of 588FL. So there doesn't seem to be any kind of time limit on it, if you'll excuse the pun.
I might pass to Jason. What are your thoughts on that?
Thanks. Yeah, I mean, it does seem that it shouldn't work that way, and particularly if we have regard, David, to voluntary administration, which is supposed to, give a company an opportunity to try and sort out its problems. The idea that any security that you enter into after that is potentially going to vest, and therefore you have to go off to the court and get an extension of time, just doesn't seem like that's the way the law should work. Now, maybe if we follow through with some of the Whittaker report recommendations, if the government ever actually gets around to responding to it, what are we 5 years after the review now and counting, maybe that will deal with some of the problems, including, of course, the possibility that 588 FL and or FM might be removed from the legislation.
Well, I agree with you on that. I was going to make that point later, but
Yeah.
I'm glad you've made it. Yeah.
I think Mr. Mirzai, Esquire, wouldn't be entirely happy with that, given that he seems to be getting a lot of work in this.
And I must note that actually 4 of the 5 cases we're covering tonight, Mr. Mirzai was lead counsel on. So just quickly to tie off this particular case of flow systems, the application was just under 58 FM, it wasn't 293. So it was established that so the ground sought was not that there was an error or an inverse, it was just simply an order sought on the grounds it was just and equitable to grant the relief sought, because essentially the administrators were allowing security to be granted to allow funding to continue the operating of the business, which was, in their view, in the better interests of all parties. So just quickly jump into the reasons, and you can have a little bit look at these later on in the next slide. But in short, the court came to the view that it was just and equitable to grant the relief on Section 58 FM because based on the evidence they had received, it was more likely than not that allowing this security interest to not vest would actually serve the interests of all the other unsecured creditors. The court did consider that at the point in which they're making this assessment and prejudice to other creditors, the positions of other creditors were more or less actually locked in because a critical event already occurred. This is a different assessment whereby, compared to a situation where a critical event has not occurred, the court expressly acknowledged that the new registration does not take priority over the earlier registration because it was an ALPAP, it wasn't a PIMSI. So all of the earlier ALPAPs and all the earlier PIMSIs were not prejudiced by an order granted on this application, which is a bit of a bubble test, but it actually, in my view, made the reasoning of the court to grant this order on a just and equal basis simpler or easier to make. Quick question maybe thought is that what if the order 58 FM was not made a condition precedent under the facility agreement? It'd be interesting to see whether or not the court would be as willing to grant the order if it wasn't made a condition precedent, and therefore in the interest of the overall company continuing to operate in the hands of the administrators. But that's a question for purely theory. Just to jump to the next case, just conscious of time. This was the fourth case is the matter of IBM Global Financing and Applied Business Technology, which is handed down by Justice Parker, the corporation's list in the New South Wales Equity Division. Here, just by way of background, the plaintiff, IBM Global Financing, leases and finances the purchase of computer equipment, both hardware and software. In this case, the plaintiff brought an application under FIRE FM and Section 293, so it involves PIMSIs. Quickly, by way of background, in late 2017, the plaintiff's in-house counsel discovered that there were errors in its internal procedures, which meant that registrations lodged by it between the inception of the PPSA in July 2012 to December 2017, so over 5.5 years, may be invalid. Following a comprehensive review, the 2 classes of error discovered were that in lodging the financing statements, the plaintiff, describing itself as a secure party, uses ABN as part of its description rather than its ACN. For reasons later on, this was not necessarily a large error, but the more important one, was that a number of registrations were made against the grant towards ABN and not ACN. People that will be, so the audience members that will be familiar with these types of cases would not have heard this story. So we've definitely heard this story before. It's not uncommon. It's in fact probably one of the most common errors made in relation to registrations, which then have been sought to be amended and then applications sought under 58 FM. It's important to note that the regulations require registration to be made under the grant towards ACN, not its ABN. Some people have argued that the ABN does contain the ACN, but the court has yet to adopt this because the regulations do not allow it.
And then, of course, just to make things really simple, if the grantor is acting in the capacity as a trustee and the trust has an ABN, then, of course, forget all of that. And it's then the ABN of the trust. I mean, it's very confusing.
Yeah, absolutely. And that's actually something that was considered then in the next case in relation to the situation where there was an ABN at the time of granting the security interests. it's interesting how the court approaches that. But so these errors made over a period of 5.5 years were not uncommon. A lot of large equipment providers in particular, given that they will hold a puny security interest, have discovered these errors almost always too late. What's important here is that IBM Global Finance in Australia, when it became aware of this systematic error, it lodged, so it conducted a large review of the 5.5 year period, which had actually covered over 3,000 registrations that were made. So you can imagine the laborious process that involved. It ended up making approximately 280 fresh registrations. The remaining registrations had either were not required to be remade for a number of reasons. One, either the contract under which they were pursuant to had come to an end, or the realizable value of that asset had then been down to the point where it was not economically viable to make new registration and try to enforce that if it needed to. So just the timing, as I said before, was that the errors were discovered in December 2017. Advice from counsel was received in January 2018. There was then a period of 9 months in which the team at IBM Global Finance in Australia appeared to conduct their review. As you can see there, I've extracted from paragraph 13 from the court's judgment that it was more than reasonable for the plaintiffs to take this period of time, considering the large amount of registrations, and it wasn't their only job to do. Which I think is a great recognition for any parties that do discover these mass errors in their system. It's a good indication of the court saying, well, look, we understand the commercial realities. So that's an observation I think the court made.
One interesting point on that when I was reading the case was that where the judge is talking about this particular issue, that the staff responsible for doing all these reviews, many of them were part-time. And you would think, I mean, without making any comment about IBM specifically, but just in general, if you recognise that potentially hundreds of your registrations are defective and you could therefore lose out if the grantors become insolvent, I don't know. I mean, I'd think I'd want full-time people on that, not just part-time people who then also have to do other things.
Not speaking about the plaintiff in this particular case, absolutely. You'd want to, particularly in relation to penalties where it's well known since 2013 and made in civil that a failure to correct the registration, get that extension of time, both on 58FM and 293, you lose that asset. In a matter of one steal, that costs the plaintiff about $23 million worth of assets.
Forge, 50 million plus.
Yeah. I mean, this is a point, it might be good for me to make this point that I was going to make later about the type of the organisations we're seeing in these cases. So IBM Global, Toll Logistics, All Leasing, which is a kind of a Australasian leasing outfit, which was in the Accolade case, and the One Steel as well. These are not small businesses who are making errors, you know, and the Act has now been around for 7 years. So not only would I expect them to put full-time people on, they discovered the error, but it's quite surprising, really, that at this stage in the life of the PPSA in Australia, that these large organisations are still tripping up in this way.
Dave, I might actually just ask you then, because as Jason alluded to before, you've had extensive experience internationally, not just, of course, in the Australian jurisdiction, but this legislation does not operate in a bubble. It's been in place in the US for a long time. It's been in place in New Zealand for a little bit longer than Australia. And not just IBM, but a lot of these companies are not just based in Australia. One would seem to think that have operations in these jurisdictions as well. In your experience, have you seen these sort of errors made by large international companies in those jurisdictions as well? Sorry to put you on the spot.
Well, look, I think that's true. There, you know, that's a fair point. That large organisations occasionally make errors. Perhaps, you know, obviously the North American jurisdictions have had the legislation for decades now. So probably when they were starting out, they might have had some of this going on. New Zealand, we haven't seen so many of these sort of large corporations. But I think it's fair to say in Australia, the situation is more complicated by the complexity of our register, which obviously the Whitaker report is is trying to address, particularly as Jason mentioned, you've got issues around, ABN or ACN corporate trustees. If we look at through the cases where extension applications have been made, the ABN is obviously a big issue. So I think that it's not surprising that there's more trips and traps in Australian PPSA because of the way we've designed the register than there are in those other jurisdictions. Yeah, so I think, yes, of course, large organisations are not foolproof, but it does seem surprising considering how much exposure there has been in the marketplace, and that they seem to be tripping up in this way in Australia. But Jason probably exaggerated my international experience. It's mostly New Zealand.
It's a pretty substantial financial risk. With some of these cases, not just the ones that James is talking about, the 4-in-1 Wyoming case, which is mentioned in one of the earlier quotes, that was their whole business. If you get your whole business wrong, if your whole business is at risk because you've mucked up your registrations, and again, it's not commenting anything about that particular matter, but we've got some companies that this is all they do is lease property out, and they're mucking up the registrations. There was one case that I think maybe we covered in the last one, I can't recall, where the finance business decided that they needed to learn about the PPS, and so they sent a clerk to a free CLE that one of the law firms was doing, and then that person was given the job of doing all of their registrations. And you just think, the mind boggles with some of these matters. I think managers really, we're preaching to the choir here in terms of the audience, but some of these managers need to get real about the risk that their business is facing if they get this stuff wrong. Next slide, James.
Yes, please. Thank you. Yeah. So actually, just on that, actually, a great way the court approached it. So it was good for the court then to just recognise the internal efforts of the team and gave it maybe a little bit of leeway in relation to using part-time staff over a period of 9 months before bringing the application. So just quickly going through, there were 2 applications, 588 FM. That was sought on the basis that the failure to register the ABN was simply by way of inadvertence. So register on the ABN instead of the ACN was simply inadvertence. The court just easily looked to the case of Accolade Wines, where Justice Parker took the view this was just simply an administrative error, and it was a very easy tick the box that they had been satisfied because of the judgments prior to this one. The court then considered that in relation to that, whether there was any likelihood of insolvency risk in the next 6 months, but no, this could be, of course, stressed by the relevant order as mentioned earlier. So just quickly saying under Section 588 FM, the court initially granted those orders in chambers, which was quite easy to do based on the precedent from Accolade Wines, but then Justice Parker quickly turned to Section 293 in the application. Justice Parker recognised that the facts did closely align with that of Accolade Wines. He recognised the potential prejudice to all PAP holders and PIMSI holders as extracted in paragraph 28. Apologies, it's not in the slides, but he said, for practical purposes, it's extremely unlikely that there would be any prejudice of the relevant type to an all PAP holder for granting this order, whose security predated the player's PIMSI. For example, a lender who lends money on all PAP terms is hardly likely to expect the security to apply to a post-acquired property purchased with the assistance of fresh finance. So just Justice Parker there expressly acknowledging the practical effect of a PIMSI in which it carves out a new class of assets. So when considering the prejudice to other secured creditors, the all PAP interests were not of a large concern to the court. In relation to what was then also subsequent all PAP holders in relation to these grantors, the court acknowledged that there may be prejudice if those all PAP holders in the interim had searched the register and not detected the registration incorrectly made by IBM Global in this instance. This is an interesting point here where Justice Parker supported what's known as the triple search. Triple search is where potential secure parties or other third parties conduct the register's search by way of ABN, ACN, and name of the grantor. Now, the regulations only require that a secured party or potential competing secured party search by way of the ACN and company name. industry practice has been to do the triple search. Triple search was endorsed by Justice Brereton in earlier judgment. And what's interesting is that Justice Brereton then later on in the case of One Steel actually appeared to, in my view, take a little step back from endorsing this approach. Justice Brereton did state that a combined grantor search was not contemplated or authorised by the Act in that case, and that parties should not rely on the triple search as evidence in support of an application of this nature, particularly Section 293. Now, Justice Parker in this case did not appear to reference One Steel, instead falling back to Brereton and Accolade when he immediately said that the triple search was industry acknowledged, and it's not uncommon for parties to conduct that sort of search. And on the basis they do the search, they would automatically see that the incorrect registration, in this instance, that contained the ABN, not the ACN, would still bring up the registration, would then come to the attention of these other parties. So there was support for this triple search, and then that was then used as a basis to determine that it was unlikely to be prejudice to future OPAP holders on the basis that it's commonly accepted they would do this search. So that was satisfied in relation to potential creditors being prejudiced. But Justice Parker also recognised the efforts of the plaintiff solicitors to decrease the potential prejudice, because this involved, when the application was made, around 50 potential competing interests, not just OPAPs but also PIMSIs, which had a large evidential burden on the plaintiffs. So just a good observation there, paragraph 38, that Justice Parker said that the steps taken by the solicitors for the plaintiffs to not only contact but bring the other potential secured parties into the proceedings, giving the opportunity to respond, really almost shifted the evidential burden. Stopped short of shifting the evidential burden, but was very good and very much assisting the court in being comfortable in making this under Section 293. So that's a good practical outtake from 293, that simply applying to the court may not be enough to sway the court to make what is an important order on 293 in relation to other secured parties, but demonstrating you've taken steps to remove this potential prejudice or at least reduce it is something that is good to note should the applications be brought in the future.
Because it won't be easy for those parties potentially affected by it to identify the extent to which they might be prejudiced by any potential order, and then make a decision about whether they actually want to participate in proceedings.
Absolutely.
Now,
Actually,
sorry, David.
The judge did make that point in quite a bit of detail, Jason, that in fact, they would have to go and work out whether they, how it would have affected them if the particular security had been correctly registered, and whether it would have made any difference to them. I just wanted to say on that, part of the judge's reasoning there was that the secured party served a request to the secured parties under Section 275, which is the section which enables a grantor or other interested parties to seek information about the security agreement. And then under that section, you've got, I think it's 10 business days to respond with the information. And the 6 fixed security interest holders that are referred to at the bottom of the slide, they never responded to that request, whereas the others all said, yeah, we don't mind, we're happy. So on that basis, the judge is saying, well, the plaintiffs have done enough there by serving that Section 275 request. But of course, these 6 were not parties to the litigation. So in a way, they haven't had a chance to come before the court. I mean, I suppose you could say, well, they wrote to them and didn't get a reply, so they, you could say they didn't care that much. But it's a bit of a leap to say they didn't respond to the Section 275 notice, therefore we won't, take their views into account in terms of joining them as parties.
Yeah, but David, isn't that part of the rationale for giving the guardian securities condition? So,
yes.
So yeah, that we give them an opportunity in the future if that there is a problem, they can come back to the court.
You're absolutely right, Jason. But if you go back to the Accolade case, Justice Brereton made a big point of saying how important it was, as James mentioned earlier, to be transparent and not to make ex parte orders unless they're a very compelling case for them. So there seems to be a bit of a disjunct between some of the statements about how important it is to make sure that other creditors' priority rights or property rights are not being kind of trampled over here, and then making assumptions. Now, you're quite right, the Guardian Securities gives them the opportunity in future, so you might say that that's sufficient. I just have some reservations, as the judge himself in this case did. So in this case, the judge did say that he expressed some disquiet originally, and then the plaintiff produced more evidence of what they'd done to actually contact the other creditors. And at that point, the judge was then satisfied. So I share some of the judge's reservations about Section 293 and the possible prejudice to other creditors and the shifting of the onus onto those creditors who may not all be, particularly where they're, they've got specific security. They're not all going to be big corporations.
Yep. Now, I'm just mindful of the time, and we have lost a few people, and that's fine. We said we were going to go for an hour. James, are you happy to keep discussing the last case?
Yes, absolutely.
And David, have you got a few more moments to share any final comments after James discusses the last case?
Sure.
Great. So, as I said at the start, we are recording this, so I'm respectful of people's time. If people have other commitments, that's fine. If they need to drop off, you'll still get the full recording. Obviously, if you're able to stay and then have any questions, then we'll address those. Thanks, James.
Great, thank you, Jason. So just tying off this one, Guardian Securities position was granted under 58 FM and 293. So the last case is that of Psych Holdings in 2018. This is worth mentioning for a couple of reasons. By way of background, in 2013, a company called Ridgeway Finance entered into a GSD with Psych Holdings as the grantor, secure payment of the loan. Now, Ridgeway Finance, as the secure party, lodged its financing statement against the ACN of Psych. Now, at the time of registration, Psych had actually entered into this documentation as trustee of a trust. That trust had not yet been assigned an ABN. So the registration was made in 2013 against the ACN of the trustee. The trust was then later assigned an ABN, and Ridgeway Finance became aware of this, but then did not undertake any changes to its registration. Now, it's important to note here that Section 166 of the PPSA does require that where registration is correct at the time of lodgement, as it was here, where an ABN wasn't available, but subsequently becomes incorrect, registration becomes ineffective 5 business days, quite a short period, our secure party acquires knowledge of the defect. Now, Ridgeway Finance did not take any steps to make a registration against the trust ABN, and it wasn't discovered until July of 2018, under which a 58 FM order was sought. This is just an ORPAP, so there's no Section 293. Just stepping through it, it was found that Ridgeway Finance's error was an incident mistake as opposed to a disregard for its statutory obligations. The judgment referred to the fact that this is a very unique set of circumstances and the section may not be widely known, Section 166. However, it didn't discharge our obligation. It just, on the weighing of whether this was an innocent mistake, it felt that generally this was a quite specific requirement, and based on the evidence, the secure party was not consciously aware of this requirement and did not appreciate the requirement to amend its registration as soon as it found out IB 5 business days. Just stepping through 58 FM, so the innocent mistake box was ticked. Next was potential prejudice to secure parties, or other creditors. So just by breaking that down, there was one other secured creditor that had already held priority prior to the granting of this GSD or PAP interest. So it did not, so whether this order was granted or not, did not impact its security position. Now, there were other unsecured creditors in relation to this application, but the court made a very interesting observation that they were not prejudiced by a later registration because the original defective registration against the trustee's ACN would have discovered the relevant security interest against the trustee company, even though the registration was defective. Now, I had thought about this at the time, in that if you were to take security over a trust, you would search the ABN of the trust to identify security interests, as is required by PPSA and the regulations. However, what is common practice is actually to not just search the trust ABN, but also the trustee ACN. And kind of connecting the dots, I think this is where the court was coming to, in where it says that the later registrations would have been disclosed to later security interests, potential security interest holders, because they would have searched the trustee company as well as the trust ABN. That's kind of connecting the dots there, but it seems to be the logical reasoning for the court to come to the view that the extension of time will not prejudice secured creditors, so other creditors, because they would have been otherwise aware of this defective registration. So then the court just simply made the order to extend the period of time, and that's where we landed with that case. I just thought it was interesting because it acknowledged a bit of an industry practice rather than a regulation requirement.
The information providers are loving this triple search, surely.
Absolutely.
It's just requiring more searches. Even though you've got the details that are required under the regulations, you search for those, you don't find anything. We're getting the court saying, well, you've still got to run more searches, because that's supposedly common knowledge now in the finance industry. I mean, what we've seen is the PPSA registration requirement isn't necessarily common knowledge within the finance industry, because we keep getting these cases from finance companies, but supposedly the triple search is.
Absolutely. And if you go into Brereton's judgment in One Steel, he actually provides a little bit of industry sort of knowledge. He refers to these search engine providers, and simply by entering the ABN, ACN, and company name, you're not just just by entering the ABN in the name, you're not just simply searching under those two parameters. Right. The software themselves may actually take into account a whole bunch of other search parameters without you even knowing it. No. And that was sort of part of his argument in stepping back from reliance on this triple search, which may not in fact be a genuine triple search. But yes, that was the last point for that case. I just thought it was interesting noting that. And so just in the last table, the last slide here, I've just put a bit of a summary and comparison in relation to these 5 cases. It's often good to look at these in the context of where the court has come to its view based on a period of time, the reason for it, and what the result has been, whether with a condition or without. So a bit of a summary there. I thought I might just end on that point and leave open to any questions from
just before I throw to David for final comments. When we could go through, I think you said at the start, there's been 40 cases on these extension applications. And I reckon you'd probably have 38 or 39 of them being granted.
Absolutely.
The only case that I can think of off the top of my head, I think the Kaizen case, the one about the builders from Dubai who said they didn't understand what it was, and then the court basically said, oh, you knew exactly what it was, and it was a commercial decision you made not to register, so we're not going to extend it.
Yeah. I could be wrong, but there was evidence of legal advice being given in that one as well. Right. And they decided not to rely on it.
Yeah. Sorry, David, did you have any final comments?
Well, look, I think I've covered. I've mentioned some of the matters that I was going to cover along the way, so that should speed things up. Just to follow on about that triple search point, this was one of my bugbears that I was going to mention, because when the Accolade decision came out, I wrote a critical piece in the Insolvency Law Bulletin about it, because I was somewhat surprised by the approach that Brereton took in that case. First, it seemed somewhat surprising that he almost treated the plaintiff lawyer's evidence of market practice as almost expert evidence, which was coming from the plaintiff's lawyer, obviously. In terms of that triple search becoming market practice, which is now being consolidated really by the IBM case, I think, as Jason said, the courts, particularly in Accolade, are really deeming the other secured creditors to have known about a security interest because they should have done a triple search. Now that's very far removed from the somewhat ironic when you look at the whole question of whether you use the correct grantor details in the first place and the way that's treated by One Steel or under Section 164 as a seriously misleading defect. Yep. On the one hand, we know, that the register takes no prisoners. The regulations take no prisoners when it comes to grantor details. On the other hand, when it comes to exercising discretion, in these cases, particularly under 293, the courts, particularly in Accolade and IBM, are saying, well, everybody knows you should do a triple search. And then, as James just said, we can say, well, they would have found out about it if they'd done a triple search, which seems to be reading some sort of reasonable searcher, almost sophisticated reasonable searcher, into the discretion under 293, which looks at whether somebody relied upon the register, and reliance is subjective there. So I think that's a very interesting tension between the registration criteria and the discretion that's being exercised here. And as I said in my article on Accolade, it seems to be suggesting, the big end of town knows that you should do a triple search, and therefore we'll impose that on everybody as a criteria when we're looking at the discretion under 293. So that's one of my kind of personal bugbears out of the way. So the only other thing I would say, because I know time is of the essence, is the statutory review. Well, Jason, I think we can be reasonably confident that something will happen this year, because it's not a state secret to say that money has been allocated to implement the Whitaker review in the mid-year budget last year.
Yep.
My EFO. So as far as 588 FL is concerned, why do we have it in the first place? There is some sort of suggestion in explanatory memoranda that it's to do with voidable security interests, but then again we already have 588 FJ for dealing with those. And of course now we have 267 of the PPSA. So we don't need, the review recommended we should abolish it, as Jason said. Not only that, it's obviously costing lots of money for administrators to have to keep rushing off to court to get extension orders when they want to take out security as part of a rescue, or to carry on trading the business while they're working out what to do. The other good thing about the statutory review implementation, it might clarify, simplify some of the issues around corporate trustee, ABN, because it does recommend that if you have a corporate trustee, you should use the ACN, which, as Jason says, just seems more sensible. Turning to my last point, really, it's been a long time now, as I said, since we've had the PPSA. How, as one of Jason's former students said in her article on the Psyche Holdings case, how long do we have to go on before the court says, well, it's no longer inadvertent or accidental, that you didn't know about the consequences of registering, or the need to register, whether it be PIMSs or the 20 business days, if that survives. So I think the courts in the early days were very generous, and they've continued to be very generous about what's inadvertent. But as I said earlier today, with some of these large organizations who are tripping up, how much inadvertence can we tolerate now that the system is bedding down a bit? So that's all I had to say that we hadn't already covered. Thanks.
So ignorance is bliss, it seems, at least for the moment. Now, I'm very mindful of the time, but if anyone had any burning questions that they either wanted to raise their hand to use their microphone or phone, or type in the question and answer box there. Just while you're thinking about that, we did have a question earlier, James, but you were in the middle of something, so I didn't read it out. So this takes you back to that very first case that you spoke about. So the question, it says from anonymous, so I assume it's from someone on the phone. On the Squadron case, was there any mention of whether the secured party attempted to contact the grantor to get another new general security deed entered into so that they could make a fresh registration within the relevant time? And there may be issues about whether the fresh deed would secure past advances, but leaving that aside.
It's a good question. And so there wasn't any mention of that in the facts. And I kind of lean to thinking why that wasn't the case, because The registration of a security interest doesn't depend on whether the date in which the security interest is granted necessarily. If a GST is entered into, for example, in January, you can register any period of time you like to perfect your security interests. It's 20 business days you must comply with to avoid that insolvency risk. If you haven't registered by that period of time, you still hold a security interest, albeit the grantor hasn't suffered a critical event. So you could still register 6 months later and not require the entry into a new GST. If they did enter into a new GST and it was drafted in the sense that it would recognise previously advanced monies, the security interest that new security interest policies would actually still start from the date of the new GST. Although if you attempt to enforce it, it would recognise earlier monies advanced. But in the point of priority contests, it would be as a point in which that security interest was granted and you registered it. So to answer your question, it didn't appear to be any discussion about entering into a new GST, but I'd be interested to see if that was the case. I can see it not necessarily being required when you step through how private FM is just simply for insolvency risk management purposes.
Okay, now there haven't been any further questions posted. So on behalf of the BFSLA Academic Committee and the Ross Parsons Centre for Corporate, Commercial and Taxation Law here at Sydney Law School, I'd just like to thank you, James, for giving up your time tonight and taking us through these cases and giving us this fabulous summary table. And also to thank you, David, for giving up your time and sharing your expertise. And I'd also like to thank everyone for participating in tonight's webinar, particularly as we went a little bit over time. So, James, I think I'm going to need your assistance to go off to court and get an extension so that this webinar doesn't best. Okay, I'll stop with the cliches. So thanks, everyone. As I say, hopefully we'll do some more of these in the future. If you do have any comments or feedback, please feel free to send me an email. I emailed all of the registrants earlier today with a copy of James's slides. So I'll resend the updated slides together with the link to the video probably next week sometime. But if you do have any comments or feedback, please feel free to send me an email. And thanks, everyone. So we'll draw the webinar to a close now. Thanks so much. Thanks, David.
Thank you. Bye.